cutting off to be much longer.
I know. At least our email addresses aren't E. They go with the E Smith.
Whether they were a homeowner, a business owner,
Oh, really?
yeah. It was them.
I get that, and I forward it on, and I just delete, and I send it back and say, yeah, wrong one.
The citizens that live within. Yeah, I'll take over.
You need a chair in the hall. A permanent chair.
I just stand there. I can hear all the things you're saying about me.
Okay.
Well, my fellow councilman told me I had to wear my hat, so.
I think you should wear his hat when he goes up.
Yeah.
Oh, okay.
And I will.
Stetson.
Perfect.
But, see, and I think that we should, if anybody really wanted to.
Are we about ready?
I think
We're ready?
easy answer.
So I don't know.
And besides that, because we're so deep.
Good evening, everyone. I'd like to call the November 1st, 2012 City Council meeting to order. And I would just like to say that Mayor Turley obviously is not here this evening, and so it's my pleasure to run the meeting, and the mayor had business elsewhere this evening. So with that, roll call, please. Cindy?
Thank you. Mayor Turley, Gary Brevetto,
Here.
Bob Carlson,
Here.
Terry Harrison,
Here.
Carol Harvey,
Here.
John Schaefer,
Here.
Eric Smith.
Here.
Thank you.
Would you please all join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. So this evening we have no ceremonies, presentations, or appointments. Cindy, do we have any additions, deletions, or corrections to the agenda?
No, sir.
That moves us to the consent calendar item on the agenda. That is to approve the minutes of the October 18th, 2012 regular meeting, and to approve an application from the Historic Ute Inn for renewal of a tavern liquor license.
I have one correction to the minutes on page 5. Halfway down the page, Councilman Harvey reported the agenda item that I called to the attention of the council was administrative in nature, not legislative, and then that changes again at the end of that paragraph.
So noted, and we'll get that corrected. Thank you, Carol.
Any other comments or questions on the two items on the consent calendar?
I have one comment. In the absence of the chief, who is on vacation, there are no issues with the renewal for the liquor license on the consent calendar.
Okay. Terry almost had his question out, I think.
No, but I'll move to approve with the corrections made by Councilman Harvey.
Second.
Okay, we have a motion and a second.
Thank you. Brevetto,
Oh, yes.
Carlson,
Yes.
Harrison,
Yes.
Harvey,
Yes.
Schaefer,
Yes.
Smith.
Yes.
Thank you. Motion carries unanimously.
Okay, moving on. We have no unfinished business. So that takes us to ordinances on initial posting. We have one item tonight, and that's the consideration of ordinance number 1174 on initial posting regarding a conditional use permit to construct a single-family residence on the property of 420 East Midland Avenue, and I believe Scott is going to fill us in on that.
Yes, thank you, Mr. Mayor Pro Tem. This is a conditional use permit for a single-family residence at the on a vacant lot that sits at the northwest corner of Midland Avenue and Boundary Street. It's in the Central Business District, and that's and single-family residential is a conditional use in that zone district, so that's why you're seeing it tonight. The proposal is for a 1,080 square foot residence to be placed there. It's pretty straightforward. We reviewed it against the conditional use permit criteria. This is the first reading of the ordinance, so I'll give you a little bit more of a presentation at the second reading. So what I'm recommending to you right now is that you approve this ordinance 1174 on initial posting and set the public hearing for November 15th, 2012.
Thank you. Any questions? Hearing none. Someone like to make a motion?
So moved. Second.
Okay, we have a motion and a second to approve ordinance number 1174 on initial posting and set the public hearing for November 15th, 2012. Cindy?
Thank you. Carlson?
Aye.
Harrison?
Yes.
Harvey?
Yes.
Schaefer?
Yes.
Smith?
Yes.
Rovetto?
Yes.
Thank you. Motion carries unanimously.
Okay, moving on. We have 2 items under public hearings this evening. The first item is to approve ordinance number 1173, eliminating the school-related distance restrictions applicable to premises holding liquor license. And for that, Cindy,
I'd be glad to start, and then the city attorney will help with any other questions that you might have. A reminder that this was presented to the city council based on your direction for us to put together a proposal for an amendment. And we did that on October 18th. Recall that there was a good bit of discussion about whether or not it should apply to this district, a larger district, a smaller district, or perhaps even citywide. And so ultimately the motion to approve was to approve as submitted with discussion to follow at the public hearing. City Attorney Smith did make a small change to the ordinance to ensure that special events that were permitted to be held on property that is not owned by the city would also be exempt from this distance. So the change, I called it a blue line, but really it's red. The change was reflected in your packet. And a reminder that this ordinance or this area can be amended at any time. It can be made larger, it can be made smaller. The map is intended to kind of mirror one that's already in the municipal code. So having said that, what questions may I answer or may the city attorney answer for you?
Well, I made a suggestion last time, and rather than nitpicking this thing to death and give an exception here, an exception there, an exception there, why don't we just remove the whole restriction entirely, and then we can just judge each particular case individually as it merits. It's got to go, when people put businesses here, even a liquor store, they have to go through a planning process. Not only that, but even if they do a liquor license, they're going to have to go through a liquor license process, and the residents of the adjoining areas certainly have input to that, and we make a decision based on public input on those particular areas. So I really see no value of obviously having any restrictions at all, because as I said, we can just judge it case by case basis, and I don't see any problem with that.
Go ahead, Aaron. I think so. What you're suggesting is that we would approve this, but we would remove all restrictions across the city.
Mm-hmm.
So anyone coming in to put in a establishment that sold liquor could put one in anywhere in the city.
Right, subject to planning commission and.
No, I don't think that's what you meant, Gary, that anyone that came into a business district that was already zoned for business would then have no restrictions. And that's, and I concur. Why put any restriction on it at all?
So could you clarify, maybe for me, you don't want any restrictions on what?
Well, personally, I don't want to have any restrictions at all, whether it's in a business district or anywhere else, because any person that comes in here is subject to review anyway by a planning commission and by the various requirements of having a liquor license and that kind of stuff. They have to go through a review process. It's automatic. They can come in here and they can put something wherever they want.
Let me clarify. What they must meet are certain state requirements that exist and that every licensee is aware of. So they've got, due process is accorded to each applicant because they understand what the rules are coming in. So those rules right now are administered by the city clerk acting as the liaison for the city council as the licensing authority. So when you have on your agenda the renewal of a license or a new license, you act as the licensing authority, and what the city clerk will provide for you are the findings that she has as an initial reviewer made, found that the licensee has met. And those are very specific. It's and we can go over those, but you don't get to, at that stage, to make a decision whether or not this particular licensee is too close to a school. So that would violate the constitutional rights of that licensee. So you either eliminate the distance restrictions citywide from now till some future council wants to establish them. And you don't then, on a licensee by licensee basis, get to decide if they're too close to a school. Or you do what's proposed, which is eliminate the school distance requirement within the mapped area or some other area that you define, such as maybe those areas zoned for central business district.
So you're saying to me, if it's citywide, eliminate this restriction citywide. If someone wants to apply for a liquor license, I'm going to give you an example, right next to the high school, for instance, there's nothing stopping them from doing that?
Correct.
Nor could we make a determination and not grant them a license on the fact that they are next to the high school.
Correct.
But they would not apply for that license or propose to build a business unless it was in a parcel that was zoned for business. Correct? This applicant, this future applicant is not going to ask to build a liquor store in the middle of Tamarack.
That's true.
So lifting all restrictions would then infer that it's only in those parcels zoned for business. Correct.
Or they would come forward with a rezoning application or
Right.
Exactly.
Right.
And at that point, we would have the ability to judge it on its merit, if it was for rezoning.
I buy that.
Before, let's move on to some other questions, if we have questions of the staff. This is a public hearing item, so I'd like to get to the point we can open the public hearing, we can close the public hearing, and then we can have more discourse. Maybe someone in the audience has something that would spur some more discussion from council. Bob?
No, my only compromise was that we're trying to encourage development in DDA, and rather than using this special downtown area overlay map, it's very restrictive, just apply it to the entire DDA area. But I would also support the citywide also. Either one is fine with me.
Thank you.
Any other questions at this point in time, or we can move to the public hearing? Okay, with that, we'll open the public comment portion for this item. Is there anyone from the audience that would like to come up and speak on this? No one's rushing up there. Okay, we'll close the public hearing portion and bring it back up to council for further comments and thoughts.
Well, I would begin with, I would amend this ordinance to lift all restrictions for all business zoned.
Well,
real estate.
citywide.
Citywide.
Because as you say, it's got to be in a business district, someone's going to put it here anyway, so yeah.
I have some other thoughts and comments, but are there others?
I just don't understand why we want to begin to determine that this parcel of land is appropriate and the next parcel, which is zoned for business, is not appropriate. It's just, in some future date, that might not apply. So if our intent is to lift a restriction that discourages business, than lift it citywide.
I think a couple of things I'd like to throw out for consideration is, there are pieces of property that are directly adjacent to the high school that are commercially zoned. And someone could come in and purchase one of those and put it in a convenience store and sell alcohol. And there'd be nothing that we could do about it.
Except hold the owner of that business to the letter of the law, which prohibits him from selling to minors.
Well, and that's, I understand. I just, my feeling is, I think that, there's some laws that are put in place for specific reasons, and I believe that having some sort of buffer around certain institutions makes sense in my mind. Council can come back at a later point in time if there's a piece of property that's not in this area that wants to come in. Council at that point in time could amend the map to include that piece of property. So I personally would not favor taking all restrictions off. We've had restrictions for many years, and I think there's a purpose behind them. I think we're in this situation because of what we did as it related to a school in the downtown area. So we made an exception as it relates to a school in a downtown area. Now we're coming back trying to retrofit and clean up a situation that we created. So that's where I sit, but others?
Eric, I have to agree with you, and I do, I don't want to see it, and it's because it concerns alcohol. I don't want to see it lifted and just go away. I still believe that if we have an ordinance in there, that we have, at least we have a starting point. And both what Gary and Carol said is true. However, that works the opposite too. If they still have the ability to go in and apply, and we can make that change. But as long as we still have an ordinance, it doesn't make it look like it's just a free ball game out there, and that they can go ahead and just because it's a business. And it may help on the other end too, by a potential business owner, if that ordinance isn't there, then, and we've seen it happen before, that they feel, well, I should be able to do this, and they get a lot of money spent and a lot of things going on, and all of a sudden they find out that they can't have that particular business in that area. So I mean, at least it may or may not catch some of them. But I think it actually protects both sides. And Aaron can enlighten me on this. I thought it was a state law, and I didn't. Because we are a home rule city, we can amend that. We have the ability to amend that and do whatever we want with it.
That's right.
Even concerning alcohol.
Yes, state law allows the city of Woodland Park to define what school means, eliminate the requirement altogether, or reduce it from the state 500-foot distance.
And 500 feet was a state standard criteria.
Still is.
So then I guess my question is, if this got removed, would, like smoking, because you can't smoke within whatever distance it is it 500 foot, or is that a separate state law?
That's separate.
I think John, if you're done, Terry, I think John was next.
I would ask the question maybe a little differently. Is this a control measure that we want to relinquish now? And I think from my perspective, I would prefer not to do that. And I think I'm agreeing then with Eric and Terry. And we have the opportunity to approve or disapprove on future requests for licenses.
Bob?
That's why I kind of came up with that compromise that just applied to the DDA area, which is we have a reason to why, try to encourage business within an area. But if we made it citywide, you may have unforeseen, like out next to CSCS, they have a lot of private property out there, and they could request their liquor licenses next door. And if it was lifted citywide, we would be in the position of having to say why you couldn't have something which now you are entitled to have because there's no law against it. And so it's better to put the burden on the business owner to make the case in citywide as opposed to just a limited area. So I would propose to, along with Terry and what John has just said, we need to keep the restriction in place because there were good reasons for it. But we perhaps need to be a little more expansive than what's shown on this map here and just apply it to DDA in general. Thank you.
If I could interject very quickly, recall that the DDA map is significantly larger than what you're seeing here, and it's significantly larger than the inclusion of Woodland Station. It's 300 plus properties, some that are residential. So if you, as we said before, this is a map that can be expanded. If you want to consider the DDA in its entirety, I would suggest that we table this and allow us to bring you that map, because it's a significantly large area.
A couple other thoughts while we're discussing this. I think we all feel that less government regulation is good at times, and that's, I believe, what Gary's thoughts are here. But I think you have to have some regulation of some things, and we regulate a lot of things. We regulate zoning. We taking the same logic, we could eliminate all zoning and do whatever, allow people to do whatever they wanted. I don't think we're going to do that. We also made a decision not to allow medical marijuana establishments in the city of Woodland Park. So, there are a lot of things that we do from a restriction perspective, and not all of them are great, and we probably should consider those at times, but just something to consider as we're discussing this.
Well, I do not disagree with your premise, but I believe that the reason that the council probably prohibited medical marijuana is because it's against the federal law. No one here yet has made an argument to me that having the sale of liquor in proximity of any school is bad. But discouraging business, in my mind, is bad.
That's basically where I'm coming from too, is, I don't want to restrict anybody's ability to run a business here in Woodland Park. I want to make this place an attractive place for business to come to, and not have all these restrictions and these, regulations and these ordinances that restrict, what they're able to do in this particular town. I think, I don't think you give the American public very much credit in being able to, decide for themselves what's appropriate for their area and what's not. I don't think, we can get to the point we can legislate everything in life, including to the point of eliminating 16-ounce drinks like Bloomberg in New York did. I mean, that's absurd, and that's violating, my freedoms and my ability to choose for myself. I don't want to live in a government where you're going to tell me exactly what to do at any particular moment in time. I mean, there's, I don't know, too many restrictions are just, I just don't think is business friendly. And we have a problem that in our society today, and that's why we're not doing as well as we can.
And I think we could sit here and have a debate all night about where that balance is. That's really what we're talking about.
Well, it's just a balance. I just don't particularly like to have restrictions on
Sure.
businesses and trying to conduct business in this particular area. And quite frankly, I can't imagine anybody wanting to build a liquor store next to a high school anyway. We got to use a little common sense here too, I mean, it's not that going to actually, business will come up here and say, oh yeah, I got to build a liquor store right next to the high school. I don't think that's going to be the case.
Terry?
So if we do nothing with it, Aaron, where do we stand? If we just stay right where we're at and don't,
Well, I think if you stay where you're at, probably the most maybe direct implication would be, and I'm pointing to the map that Cindy provided at the initial, when this was brought up initially, before you had a first reading ordinance. And she did identify the new school that was approved through the rezoning that was done right downtown. And I think the implication that I see is that now you've got a radius of 500 feet around that new school, 400 for hotels and restaurants, but 500 for every other sort of liquor retail seller who is essentially frozen out of establishing a retail liquor license, licensed premises there.
In our core downtown.
Correct. Yeah.
Right.
And
other than the ones that were there before we let the school come there.
Sure. They're grandfathered.
Yeah.
So they get to stay, but a new licensee would not be able to come into that area.
So if somebody bought the Ute from Mike and applied for a new license, he couldn't serve alcohol in the Ute.
That's correct.
Yeah.
And if you remember that night, we went forward with approving a liquor license or the item right before for the new place next to Joni's, right before we approved the school.
Aren't we clever?
Yeah.
So
Timing's good.
one had to occur before the other.
So we shouldn't have to play those games.
So, if there's any other burning items, if there aren't any, I would look for a motion, I think.
Well, if we do
understand.
that, if we call the question now, then the motion is for this overlay. Otherwise, if it's defeated, we would go back to the previous restrictions.
Well, yeah, so we can have a motion to approve or to approve with an amendment or, a change in the map, a change in removing all restrictions. All of that is open to whoever the motion maker is.
Make a
And we
motion.
can second it and we can vote on it, and if the vote doesn't pass, then we are back at the table and we can make another motion and go through that process unless we tie, which we could. And if we tie, then this automatically gets tabled to the next meeting. So those are really the options. I think I've covered them. Okay?
I make a motion to approve without restrictions.
Second?
Okay. And so we would make a motion, so that's a motion to approve basically eliminating all restrictions as it relates to the
School-related distance requirement.
thank you. I was searching for
Citywide,
words.
Is that correct?
Citywide, is that?
Yes.
Is that the intent?
Yes.
Okay.
Question then, does that nullify the ordinance as written, or can it be amended to reflect that?
It can be amended to reflect that.
Is there more discussion? So we have a motion and a second. Cindy?
Everyone clear, we're going to approve 1173, amending the ordinance. The city attorney will do the language that this will apply citywide. Harrison?
No.
Harvey?
Yes.
Schaefer?
No.
Smith?
No.
Bravetto?
Yes.
Carlson?
No.
Motion fails. 2-4.
I would move to approve 1173, ordinance 1173 as it is written.
Second.
Okay, we have a motion and a second to approve ordinance 1173 as presented. Is there any discussion?
Well, I would prefer to have that as the last option, because we certainly want to pass something tonight, okay? But I would prefer to have the motion that we restrict it to the current boundaries of the DDA, not just that special area, but to the DDA, which is between the city and this. It gives us much broader. But the purpose of the DDA was, in fact, to encourage development of businesses in this area. point was made that there are a lot of residential residences in this area. But that, of course, would take a rezoning decision by this council in order for them to be able to sell liquor, and we could stop it at the rezoning stage. So it's kind of a compromise between the full city and this very, very restricted piece, where we're still going to be coming in with lots of exceptions. Every time you have an event in Memorial Park, for instance, we're still going to have to approve a liquor license in there. And this would eliminate that.
It's a special use,
No?
but,
Incorporated that language into it.
Oh, okay, okay.
yeah, but
If we were to consider Bob's suggestion, then we would have to recall the motion, I would assume. And then I would ask if we considered that route, every new property that is included in the DDA, if that should happen in the future, would automatically get this this permission to have liquor sales.
it wouldn't necessarily have to. We could pick those DDA boundaries today and set it in stone so that new properties added wouldn't necessarily get that.
Then what's
Or
the use of doing it? I go back to my original premise.
just to set a different.
Lift
just to
them
set a
everywhere.
Different boundary. I think Erin had something she wanted to add to that comment.
Yeah, and I agree with Pro Tem Smith, Mayor Pro Tem Smith. On yes, on the answer to the last question. You can freeze it today as a snapshot. I want to get to the issue of how this could affect future zonings, though. And what I would be troubled by would be a future zoning coming before you, and everything else looking okay, and then the council deciding that they would deny that zoning on the basis that by rezoning it to business, there could someday be a liquor licensed premises there, and because of that, that was going to be too close to, say, the school that was right next to it or some other use, and so for that reason you would deny the zoning. That, I think, would cause me quite a bit of concern, and I think that would be may be a basis for challenging that zoning. And so for that reason, I don't think that you'd be able to make these decisions on a future zoning by zoning basis.
The question of future zoning had to do with future inclusion into the DDA. If we were to go the route that Mr. Carlson has suggested and make this overlay include the current DDA boundaries, would all future inclusions in the DDA then be exempt from the 500-foot?
I think that's your decision. I think
Yeah.
that's you
Not
to discuss that.
necessarily, yeah.
It doesn't have to be, but it certainly could be.
Right. It's
to
how
provide for that flexibility that I think you're looking for.
Right. It's how you would it's how you would amend it. It would be
Right.
for the DDA boundaries as of today, or you could say the DDA boundaries as amended from time to time.
Right. Bob, I think, had his hand up, John, and then we'll get to you.
I would have no problem with extending this to future DDA boundaries, but because the purpose of rezoning or increasing the boundaries of DDA is that you want to encourage businesses in that area. And so just the same reasons you've got the current boundaries. So to be logically consistent, it should be applied to any DDA property.
Okay. John?
Well, before we take action on this potential motion, I'd like to take advantage of the city manager's offer to show us a map of what the DDA actually covers, because I don't know.
Yeah, and I think that's a good idea. We do have a motion and a second. As it currently stands, we could move forward with that. I mean, I'm okay with continuing this discussion for a little while longer, if that's okay. We could look at the map. I think at this point in time, the procedure while they're bringing the map in, we either move forward with the current motion and the second, or the motion maker would have to withdraw his motion or amend his motion for us to move forward. So, so what's the council's pleasure? Do we want to move forward as it sits with the current motion, which is to approve as is? that's on the it's on the table, or do we want to see the map, and does the motion maker, who made the motion?
Yeah, are they bringing the map in?
Yes, we're getting it.
And David or Aaron, could you tell us any pros or cons that you, or maybe Aaron, that you can foresee about us including the entire DDA in this, and future properties that may or may not be brought into the DDA?
Thank you, Councilman Harrison. I think that really what you're faced with is purely a policy issue. Council gets to decide how they want to do this and where they want to, what area they want to have be free of the restriction. I see a couple of implications. Just like I was with respect to having this be a floating boundary based on future amendments to the DDA's boundaries. And that's really the same concern that I had with the future rezonings. If council is going to have to consider every inclusion into the DDA with, oh gosh, there might be a liquor retail facility there. How close is that to a school? Too close to a school. I'm going to turn it down for that reason. You know, I see that as sort of a tail that would wag a dog in some ways. I have less concern about that from a constitutional standpoint because I think there is quite a bit more discretion when the city includes area into the DDA. The second issue that I would speak to is that once this horse is out of the barn, once the barn door is open and this horse is out, it's going to be very difficult to put it back. And that's because once you make the area so big and eliminate the restriction, and it is inhabited with liquor licensed premises, should a future council decide that wasn't such a good idea and want to skinny down the area, wants to go back to a smaller area with no restrictions, or say go back to a citywide with the 500-foot restriction from schools, then what you do is you create all of those existing liquor license premises are now non-conforming uses. So you've created sort of a something that may affect the value of those businesses, you know, something that acts almost like a cloud on title for those businesses. So that's my other thought, that by making it somewhat broad, you somewhat tie the hands of a future council is all. But this council has the ability to do that.
With that being said, then, Eric, I know how big the DDA is. I'll repeat the motion to accept 1173 as written.
So the current motion, so at this point in time, that's the current motion. We do have a second. Is there any more discussion? Otherwise, we'll call the question. Okay, Cindy?
Thank you. Motion is to approve 1173 as presented. Harvey?
No.
Schaefer?
Yes.
Smith?
Yes.
Brevetto?
No.
Yes. Sorry.
Carlson? Yes?
Yes.
Harrison?
Yes.
Thank you. Motion carries 4-2.
I'd like to thank everyone for their thoughts. I think we understand, and we don't always agree, but I think if nothing else, we've moved something along here, and it can always be amended and changed in the future as new information comes to us that might make it worthwhile to do so.
Evil convenience store owners.
Yes, exactly. Okay.
I'm one of them. Leave me alone.
Moving on, so item 9B on the agenda, I'm going to go ahead and read this in, and then I'm going to recuse myself, and Terry is going to take over as the Mayor Pro Tem. I don't know what that is, but so item 9B was tabled from October 4th, 2012. It is to consider an ordinance 1169 amending the parking requirements for multifamily residential and the addition of an alternative parking plan option. And Scott is going to go through that, and I'm going to step out of the room.
Councilman Harvey asked me if I'd wear my hat, and I told her I would.
It's very authoritative.
Anyway, Scott, you want to go ahead and get us through on this?
Sure. This is a public hearing for a code amendment to adjust the parking requirements for multifamily and to add a section called alternative parking plan option. The purpose of the code amendment is to bring our multifamily parking requirements more in line with what we think is the appropriate demand and more in line with what other similar communities around the region require for their multifamily projects. We did a lot of research on this, and it was the result of that research was that we were on the very highest end. If you'll look on page 2, there's a chart of your staff report. And it shows that Woodland Park had the highest parking requirements for 1-bedroom, 2-bedroom, 3-bedroom units on top of requiring guest parking. And feedback we've received from developers and applicants is that that's on the high side and maybe too much and maybe a deterrent to multifamily. At the very minimum, it creates probably too much parking, too much pavement, which increases stormwater concerns, aesthetic concerns. So we feel that it's very appropriate at this point, given all those considerations, to modify them and bring them down a little bit. In that same chart, you can see what we're proposing that it be changed to, taking 1-bedroom units from currently requiring 2 spaces per 1-bedroom unit down to 1.5, taking the 2.5 spaces requirement for 2 bedrooms down to 2, and then taking the 3-bedroom requirement of 3 spaces per 3-bedroom unit down to 2.5, and then eliminating the guest parking requirement. Again, it's important to remember that in doing these are just minimum requirements. If anybody ever felt like their market demanded more spaces than what's the minimum is required, they could always do that. It's not precluding them from providing more spaces if they feel they need to. And then this alternative parking plan came about during this code amendment review process. Staff felt that because we don't really have any mechanism right now to vary parking requirements, that an alternative parking plan provision would be helpful in further fine-tuning a parking requirement to a particular type of development. There's all kinds of development, and not necessarily they aren't all necessarily created equal. We have some other tools in the code right now to help fine-tune that parking requirement. We think this one will give us another tool. And basically, what it does is allow an applicant to come to us with additional supporting information to help justify a reduced parking requirement where it might make sense, and it allows the staff in an administrative review to make that decision, or Planning Commission and Council in a review that requires a public hearing would be the final say on that request. And we think that it would be very helpful to make sure that we're not requiring more parking in certain situations that we might not need to. This has gone through several work sessions with the Planning Commission. I think at least 3 work sessions, so we were able to go through these issues and fine-tune this proposal. And we would recommend that you approve it in Ordinance 1169. Are there any questions?
Scott, my first question was on guest parking or common areas. Did the Planning Commission, or in your research, did you discover that a larger multifamily project might require guest parking as opposed to, say, a smaller unit with under 25, or smaller building with under 25 units versus a unit or a building with 168, for instance?
Right.
Why would you want to do away with guest parking altogether?
to answer your first question, we didn't see, in my research, didn't see any distinctions between size of projects in terms of whether guest parking, they either was required, or they either required it or they didn't, irrespective of the size of the project. But in terms of why we wouldn't keep that requirement, in my experience, these parking requirements take into consideration in their numbers that they establish a certain amount of guest parking. That those numbers kind of build in some guest parking.
So
in
the
other words,
formula itself lends itself to guest parking.
Correct. And again, if like an apartment developer thought that their market was people who drive lots of cars, or this market was an area that needed more parking spaces, they could always still build that into their project if they felt like it was appropriate.
Okay. Then on the alternative parking, what kind of scenario would you see that in? If someone came forth with a project that would be in the downtown district overlay that we've keep recreating, what would be appropriate? What would fit that definition? What would the project have to come forward with to say, I'm going to have this many units in Woodland Station somewhere, but my parking is going to be where?
Well, if there was provision for on-street parking, that would be a consideration that we could factor in if it was available 24 hours a day. That definitely mitigates the loss of, or the non-provision of on-site parking. It would be one that comes to mind. Another one that comes to mind is somebody came in with a multifamily proposal that was more geared towards seniors, and it's pretty demonstrable that seniors have less cars, and in most cases. Maybe not all, but I think if on average you would...
Don't go down that road. You got a whole panel of seniors here with more cars than dogs.
I'm sure there's exceptions, but at least based on the experience of one of our apartment complexes here in town over by off of Evergreen Heights across from the fire station, that one is geared towards seniors, and they have a surplus of parking spots because they just have a lot of folks that don't even have cars. So situations like that, in situations that we maybe not are thinking about that may come in the future, that if somebody's got a really good case for it, I think we should leave that option open for them to try to convince us.
I think on the merit alone of comparing it to other communities with similar landscape, similar density, and the fact that we really don't have a comparison in the community itself for a large multifamily project, I think it has merit. I was concerned when I read through the notes from the Planning Commission work sessions that we had written off a requirement for guest parking, but I think your formula probably does accommodate that.
More questions? John?
A garage counts as a single parking?
Under the ordinance, yes.
Okay.
Gary?
No, I'm fine.
Bob? Scott, how big is a required parking spot that a developer or anybody, how big is that space? Yellow line to yellow line?
Typically 9 feet by 18 feet.
Do we ever reduce that or increase it for any reason other than handicap?
I think we increase it if it overhangs a sidewalk. I think that's the scenario Bill's gonna.
It depends a little bit on the parking configuration, diagonal, head in, those kinds of things, so how close it is to the sidewalk. So in our engineering specs, there's a whole chart in there on different parking configurations and the size of the individual parking stalls.
So we have a formula that we actually use to determine that.
I don't know that I would qualify as a formula, but we definitely have some standards for parking.
And on this, Scott, have we taken into consideration a handicap parking area for a complex of some type, whether it's 25 units or 160 units.
Yeah. This wouldn't change the number of handicap spaces that
They're
they'd
still
have to
required.
provide.
That
Yeah.
amount is still required.
Yeah. And size, or sizes of those spaces are regulated.
But the same number of handicap spaces for a 25 housing unit and a 160 unit, that number's not gonna change, even though the number for the developer is gonna change for the required for each unit 1.5 parking space.
That's my understanding, but
The ADA regulations require a certain percentage of the total parking spaces to be dedicated to ADA. That's not changing.
Scott, I had another question about, I guess I don't want to get off this guest housing or guest parking issue. If the project has a community house or a community building, how would you determine parking spaces for that? Is it based on square footage?
well, the way the parking ordinance is written right now, there would not be any additional parking required for a community, like a recreation or a meeting space. As the way it's written, there would not be an additional requirement for parking for that space.
Did you discuss this in the work sessions with the Planning Commission?
No, that's the first time that particular topic has come up.
I think the logic would be that the folks that are using that are folks that live there, and they would walk from their apartments to the community center area. And if there were guests, say, for a particular event, they would be absorbed in the guest parking that's been determined by the formula that arrived at these numbers.
Okay.
Any other questions for staff or Scott? With that, we'll open up the public hearing. We don't have anybody signed up to speak on this, but if there's anybody in the audience that would like to, please come forward. Seeing none, we'll close the public hearing, and we can have more discussion. Or we can have a motion. Bob?
I'm ready to make the motion. I move to approve ordinance 1169, amending the parking requirements for multifamily and adding an alternative parking plan option to the City of Woodland Park Municipal Code.
Second.
We have a motion and a second. Is there any other discussion? Deliberation? Fist fight? Nothing, huh?
I think that we may have an oversight in not addressing parking for a community building. But having said that, go ahead.
You know, and Carol, I really think you're correct, but it seems like, and I never lived in an apartment complex.
I have, and community buildings are used by more than just the residents. They host baby showers and birthday parties, and you have a number of people who will come onto the premise of that establishment, and they're not going to have a place to park.
But I'm not sure that's something that we need to address as a council, whether it's the complexes, the apartment complex needs to address that and bring that with their project as their,
But we're
and
not,
justify it then.
we're not making that a requirement of the project.
No.
We are saying with this ordinance that we only have to accommodate parking for the units themselves. And I would assume in a large complex, you're going to have a community building and it's going to need parking, but we're telling them, no, you don't need to put any parking there. We're gonna absorb it in your regular parking spaces.
Bob?
Well, the drivers here are the size of the bedrooms, okay? You have this, then you have to have that many spaces. There is no driver from the community building. Is there a separate ordinance that requires a certain number of spaces for a different kind of facility, like a community building?
Scott?
Is the question, is there another requirement for a community building?
Right.
I don't think we have that specifically as a parking. Yeah, I mean, typically we would look at that as an accessory use to what the principal use is, which is the apartments. I mean, if it was a recreation center by itself, then we would have parking requirements for that. The fact that it's on the property of an apartment building, just for those owners, we would not typically require extra parking for that. That's considered an accessory use.
Well, I mean, since we're dealing right now with just apartments and not community buildings, but some apartment complexes do have community buildings, can we come back and address that as a separate issue? And say, if you have a community building, that is considered a facility that will require parking,
Probably
in
be
addition to, whatever the apartments have.
It would probably be best to add it to this amendment if that's the direction you want to go in, rather than coming back later or trying to deal with it in a different way. It would be better if it was up front for a developer what exactly their parking requirement was.
Certainly, if council wants us to head that direction, there's got to be examples of this somewhere. Typically, for other uses, we do so many parking spaces per square foot of the building for retail, for example, or for commercial, or for other types of uses. What we don't have the ability to tell you right now is what is that number for that specific use.
And that's why I asked the question on, is it going to be different for a project with a smaller number of units, vice a larger project that I can guarantee is going to include a community building, and to simply say, well, that's an accessory building and we'll deal with it when it happens is short-sighted.
Perhaps, but again, the larger the facility, the greater the chance for vacancies. The apartment complexes roll that into their formulas too. I don't see the issue as a significant problem, but we can certainly look into it to see what other examples might exist. If it's a 200 square foot facility, that would require, one half of a parking space. It just depends on the size. So if it's council's desire for us to look into the community building aspects and impacts onto an apartment complex, allow us the chance to do that, if that's your desire as a council.
To do that, we have, Gary, go ahead, I'm sorry.
Let me see if I have this right here. We have an enterprise that wants to come in here. They want to build a multi-family facility, whatever the case may be. And we're dictating to them how many parking spaces they have to have, when in fact we're not allowing them as a free enterprise system to determine basically what is marketable to that particular site. We're dictating that. I mean, we take the decision-making process away from these enterprises? I mean, if they didn't put any parking spaces in there at all, you think anybody would even buy a unit in that place? I mean, are we kind of over-regulating this thing or what?
No, I don't think so. I think what staff's trying to do is give them a minimum that they're reducing it, and considerably. I mean, we have a requirement for more parking than anybody else, as it showed you in your packet. They're bringing it down to an absolute minimum that they think.
But who thinks?
That staff thinks, an absolute minimum that they think that, and correct me if I'm wrong, even to entice a developer to come in here and build one. Because I can promise you, you get rid of a parking space or two, you've got more ability to increase the size of the complex.
Probably true, but then again, what would be, a potential resident at property? They don't have a parking space, they're not going to buy in there. So
That's true.
We're not allowing the free enterprise system to do what it's designed to do.
But I think we're minimizing it, bringing it down lower.
Terry, I have no issues with voting on or calling the question as is.
Any other discussion? We have a motion and a second. Cindy?
Motion is to approve as presented. Schaefer,
Yes.
Brevetto,
Yes.
Carlson,
Yes.
Harrison,
Yes.
Harvey.
Yes.
Thank you. Motion carries unanimously.
You know, I gotta thank staff, and Erin really wants to thank them because she's kept me out of jail for 8 years, and now they let me in this seat and only give me this to deal with.
I could leave for the rest of the day.
Oh, that is yours.
All right. Gotta figure out where we are. Back to my agenda. Okay, that concludes item 9, public hearings for this evening. And we'll move on to item 10, new business. We have 2 items actually under new business. The first item, 10A, is to consider request from Pammy Carter to operate a small home child care business for a maximum of 8 children located at 926 Forest Edge Place in the suburban residential district. And Sally is going to provide us a presentation.
Yes, thank you. A couple of years ago, in 2010, new regulations were established with respect to in-home small daycare facilities. Prior to the change in regulations, these were considered a conditional use permit in the residential zones. We modified that ordinance and allowed these to be permitted conditionally, which meant that they had to meet a certain amount of standards, as well as notifying the neighborhood, the surrounding property owners, and if a surrounding property owner had an objection to this particular use, then they had an opportunity to request a hearing before the City Council, and that's why we are here today. Jim and Julie Kirkham, who are the owners of 936 Forest Edge Place, are adjacent to the proposed child care home, and are concerned about it being established. Jim and Julie live in California. They lease this property. However, Julie's brother, Joe Watson, lives here in the community, and he is representing the objectors this evening. Also in the audience are Pammy Carter. Pammy, raise your hand. And Kelly Nelson, her daughter, who will be the providers should this be granted to them. In your packets, there is a map that shows the location of the proposed child care home at 926 Forest Edge Place. The standards require the notification of properties within 150 feet of the subject property. That is shown and outlined in red. And those notices went out in accordance to our standards. Pammy Carter also submitted a site plan of her home showing the driveway, the home placement, and the outdoor area that will be proposed for their facility in the backyard. And I might note that this facility will be only for infants and toddlers, although that's not specified in the conditions. What is specified that there is a maximum number of 8 children who are allowed to be cared for at any one time and within the home. This is a photo of the Carter's home. As you can see, there is quite a long driveway. It's set back. The objector's home sits just to the right of this home, or to the east, and that's a photo of the objector's home behind the spruce trees, and you can see the location of the Carter's edge of their driveway here. And then I also have a photo of the home that is just to the west of the Carter's home. This is the corner of the Carter's home, and there's the other immediately adjacent home. And I also shot a photo looking in the backyard. It is currently fenced in this back corner. There is another home to the north. The area for the children will be back in the north western corner of this yard. Because this is permitted conditionally, we apply the conditional use criteria with the evaluation. I'll briefly go through those criteria, starting with the first criteria, which deals with the need and adequate mitigation. There currently are 3 child care home facilities in the Woodland Park area. I have spoken with the child care specialist who confirmed the need for this type of use. To emphasize that, we've also had a recent child care center, Happy Trails, that is no longer in business. So currently there are 2 operating centers plus the baby station. This facility is required to meet state licensing requirements, which are fairly rigorous. The play area is limited to a small fenced area in the back of the home. The toys are to be stored out of view from the road right-of-way. And we are adding, the provider has agreed to an additional condition for this, and that is that they will limit their operations to specific days and hours. Those will be Monday through Friday from 7 a.m. to 6 p.m., and that is a added condition that was suggested by the opponents, and the provider has agreed to that. So we believe that the need is there, as well as adequate mitigation, especially by reducing the operation hours or specifying those Monday through Friday, 7 to 6 p.m. Number 2 deals with shall not endanger the public health and welfare. Safety is a primary concern for a licensed child care provider. A fire inspection is required as part of their state license, and that the home was constructed in 1981 under the applicable building codes. The third criteria deals with the value of protecting the value of vicinity properties. I had spoken with a local appraiser. He shared with me that value is based upon the location, the condition, size, and quality of the home, not whether a child care is operating in the neighborhood. With respect to harmony in the neighborhood, it will meet the state licensing requirements and be limited to weekdays and 7 to 6 p.m. Conforming to city's plans, our comprehensive plan does encourage family-friendly community. Providing quality child care is something that families do need in our community. With respect to the city standards and regulations, the applicant understands those regulations and will comply with the home child care codes. Dealing with traffic, 8 children. The total number of trips with cars coming and going could potentially reach 32. These roads are designed to handle that traffic, and we do not believe that's an issue with 8 cars in the morning, 8 cars in the afternoon. That's considering whether there are individual children being dropped off by parents. With respect to the topography or the surface drainage and the environmental situations. This is a built-out subdivision. There will be no land disturbing activities. Adequate water and wastewater disposal. This home is on city services and should not be a problem. And with dealing with safety, it must comply with the fire inspection. Lastly, the architectural design. There are no changes to the exterior, and the fencing will add a small play area in the back. To quickly review the conditions of approval, state licensing and local regulations will be in compliance. A city business license is required. Toys stored out of sight from the road right-of-way. Parking limitations, that there not be more than 2 cars for more than 15 minutes on site. That takes care of the drop-off and pickup. Fencing will conform with our current standards in Chapter 1842. Signage also conforms to the signage standards in 1848 as it applies to the suburban residential zone. And lastly is the new condition number 7 for the hours of operations to be limited to Monday through Friday, 7 to 6. Thank you for your attention, and our applicants are here as well as the objector.
Sally, before we move to questions, could you touched on it very briefly at the beginning that this is a new process. Could you briefly describe what caused this new process to come into being?
The new process was that we were approached by other child care providers who said that we had a fairly onerous process with a conditional use that was not only time-consuming but expensive for these small home operations to operate, and encouraged us to research other communities. Most other communities just do an administrative review, very much like a regular home occupation, and approve them with a few minor conditions. So the 2 operating home daycares, currently we have had no complaints from their neighbors. The other home that operates here in Woodland Park is outside the city limits, so we wouldn't hear those complaints.
So we were trying to minimize the burden on child care providing entities by making this an administrative review, and therefore reduce the amount of bureaucracy. And as that came before council still wanted an opportunity for the citizenry that might be affected by this to have an opportunity. And as those things have arisen, they have come to you. Have we had any that have gone through without council review, that have just gone through the administrative review?
Since the new code was
Correct.
Established, we had one other daycare that came forward, and there was an objector and did have a hearing. Barb Costello's home occupation went into effect. We had no complaints. She has since, however, moved out of Woodland Park.
Thank you.
Thank you, Sally. Are there questions of staff at this point?
I've got the pros and cons of both sides. I can confirm that there is a real need for more child care in this city. My daughter had to turn down 5 substitute teaching jobs because there was no place where she could put our son while we were away. So the market there's a market there for people to provide this service. On the other hand, I also am concerned about the statement that having an active child care center won't reduce assessed value. We have down Lake Street here a child care center. I think it's Lake and West. Its yard is just full of children's slides, swings, toys, and I don't see them being put away at the end of the day or anything. Can you tell me how this would be different from what that is,
Yes.
which I wouldn't want to buy a property next to it?
Yes. The preschool in the Pines that you speak of is in a commercial zone. It is a permitted use for a child care center. This is a home.
So, okay.
Very, very different.
Limited to how many children
There is no limit.
on this one?
On
Proposed.
this proposal is limited to 8, maximum of 8. In a business, commercially zoned property, you can have a child care center based on the size of your facility, based on the state licensing
Okay,
regulations.
so this property will be totally different then.
Totally different.
Okay.
Do not compare it to a center.
Thanks for the clarification.
The question I had was on parking limitations. How easy is that to enforce?
Yeah.
Two cars for no more than 15 minutes? Have you had any indication that the other facilities have had an issue with that?
Yeah, it's not an issue. There's plenty of parking. The provider would be there all day long, and then the parents would be coming and going and not staying for overlapping more than 15 minutes.
How can you guarantee that? How could you guarantee that 4 parents wouldn't show up at the same time?
I think maybe we could ask that question of the applicant and what their thoughts might be.
Yeah.
I don't know if there's any way to guarantee.
You can't, is my point. That's rhetorical, but how would then someone address that? Would that be an enforcement issue with the enforcement officer or with the police department?
It would be an enforcement issue with our code enforcement officer, talking with the provider about trying to stay in conformance with the standard.
John?
What kind of fencing is permitted under Chapter 18.42?
In the rear yard, you can have privacy fencing.
Can you have chain link?
You could, yes.
Okay.
There's a wide variety of options of fencing in the rear yard.
Okay.
And I guess a question along those lines, there's no covenants or anything as it relates to this area. I mean, one of the things to consider on other potential
Yes.
projects like this is screening may not be allowable in certain areas due to covenants.
Yeah, I'm not
So-
aware that the covenants would affect this, nor is there an active homeowners association.
Okay. Terry?
Yeah, first of all, Bob, you need to find out the history of the building that Happy Trails is in. You may reconsider your statement.
You can get with me afterwards.
So what, it said there that it's infants and toddlers, but, that's, what do we consider a toddler?
I think the provider would be able to answer that question. It's all well-defined in the state code. Mm-hmm.
I mean, there's an age.
Yes, there is. It's,
Yeah.
I think we can hold that question for the applicant.
yep.
Are there other questions of staff? Otherwise, I'd like to invite the applicant up to maybe answer a couple questions or make a statement. Okay? The applicant come forward. Ms. Carter, how are you?
I'm just great. How are you?
Great. Can you state your name and address for the record, please?
It's Pammy Carter. Address is 926 Forest Edge Place, Woodland Park, Colorado.
Great. Thank you very much.
80863.
Thank you very much.
Good. I would first like to thank Sally. She has done a fantastic job as far as helping us to get to this point with the zoning. And I would also like to say that I truly regret the concerns that the Kirklands have with this project that we are trying to do. The need is tremendous in Woodland Park for child care. Kelly opened the baby station in the late 90s. It is still in operation to the max. And of course, 2 of our daycares have closed here. If we were not in the business of caring for children, we probably would not have realized the extreme need that we have in our community for daycare. And I'm hearing, and correct me if I'm wrong, that the issue with the parking situation, with the experience in the baby station, we will have a parent drop a child at 7 o'clock. We may have a parent drop a child at 10 o'clock in the morning. Pick up in the afternoon. A parent may pick up her child after, say, 3:30, especially teachers. And then we may have a pickup at 6. There is no way to know when the children are going to be picked up, except for the experience that we've had at the baby station as far as drop-offs and pickups. Another thing is the fact that we are keeping infants and toddlers, which according to the state licensing, that's from birth to 3 years old. So as far as the outside toys, I think you addressed that issue. We have to provide, according to state licensing, 75 feet per child, which we would have 8 children, which would be around 600 square feet. But you also have to consider that our children are infants from birth to 3 years old. And the outside time recommended by the state is that it is they're outside according to the weather, if it's good weather. The experience we've had at the baby station, we can't take a 3-month-old baby outside, when the weather's cold or there's windy, which we have a lot of that here in Woodland Park. So that to me is not really an issue. As far as toys, it would be maybe a couple of riding toys, and this would be for summer. There would be a couple of months out of the year that the toddlers would be able to go outside for maybe an hour. That's all the experience we've had with that at the baby station. The experience that we've had with child care has been since the early 90s. Kelly is director qualified according to the state regulation. I'm director qualified according to the state regulation. Everything that we would do, which as we've done with the zoning, is according to city regulation that you have set up, which I appreciate that because child care is extremely important, and there are many safety issues. It's the welfare of little children, and the state is they have tremendous regulations and procedures and policies that you have to apply by to be able to be licensed. So I don't know the questions that you have. Kelly can help answer some of those questions. I got bronchitis. I don't even know if y'all can understand me. But I appreciate y'all having this hearing, and I hope that after questions are answered and issues are cleared up, I'm hopeful that the opposition will feel much better about this venture. Our community needs it desperately. We have worked in public as far as contributing to our community since we've been here in the early 90s. It's important that we all come together, rules and regulations be complied with, and questions
Well,
If there's any questions you have or what.
turn and see if there's any questions. So, Ms. Carter, thank you for that.
Thank you.
Hang on 1 second. Let's see if there's any questions from council for either one of you. Any questions? No? I guess not. You answered all the questions, so thank you.
Oh, well, thank you.
We did receive in our packet an email, I believe, from the Kirkhams, and Mr. Watson is here this evening to speak on their behalf, and so I'd like to invite him to come to the podium. And
Hi, I'm Joe Watson.
excuse me.
Yes.
You stated your name. Can you state your address for the record too, please?
My address, 1247 Mountain Meadows Drive, Woodland Park, Colorado.
Great, thank you.
Okay. Their concern is the traffic issue, and actually, the toddler, from birth to 3 years old, is not actually a condition of the okaying this, correct? So they could change it at a later time to older children. Okay, and this house is part of their retirement income, and they don't know what effect this is going to have on them being able to rent it. That's one of their biggest concerns. If there's a child care next door. So that's it. The traffic, the hours were a concern, and whether or not it'll be harder to rent with the daycare next door.
Okay.
Any questions?
Are there any questions for Mr. Watson?
Is the property currently rented?
Yes.
Terry?
And this might be out of selfishness. Joe, you're an agent. Would you?
You know, I don't know, Terry.
Would you think it would reduce the property value?
It all depends on what the daycare looks like. The two that are here, I've driven by both of them. One, you can't even tell it's there. The other, it's real obvious. Real obvious. So, and there are people coming and going from that one when I've gone by it.
But in that case, they would not be in compliance with the regulations that govern the operation of that facility, so it could be addressed.
That's true.
Through code enforcement.
But the one that is obvious, you can see all the toys from the road.
May I ask a question?
Sure.
If it is it a center or a home?
It's a home.
Home.
It's a home.
Okay.
Yeah. And the other one, you can't even tell it's there.
Wow. She's doing young children, and that one that you can see that's all.
Excuse me, if you're going to ask a question, you'll have to come to the microphone because we've got to have that on the record. So the question was that a home or was it a center? And
Yes.
the answer was it's a home.
The two that I drove by are both homes.
Okay.
In
Great.
residential areas.
Great. Okay. Other questions from council? Bob?
That was in my question before, was there a difference between the outer appearance between what I saw down here in Lake Street and this home? And they assured us that codes would require where it's not obvious. So I
Well,
think
it's
we have
obvious at that.
So we need,
one
that's a
house.
code enforcement issue.
That's correct.
Rather than being the norm. And I would suspect that and I can let our folks here answer that, is that they would go with the non-obvious solution.
You would hope so. So that's their concerns. And I don't know how to answer the rental part of it. I've never been involved in that, so.
Other questions? Bob?
Well, maybe if their business is really successful, then they'll rent the house.
There you go. And can it be a condition of approval, if you do approve it, that it is stated that it is infants to 3-year-old, and that they can't change it to,
The answer is we can, I believe, do that as a condition of approval, can we not? Since it's a conditional use?
I think that you would want to ask the applicant.
Sure.
first.
Yeah.
But I just answered the question, but we could, but I do believe that that's something that if we choose to consider that, we should ask the applicant their thoughts.
Okay.
So, anything else? Okay. So I think we're ready. Thank you very much. I think we're, I guess I should ask, is there anyone else in the audience that would like to, since we've opened this up, would like to speak on this? No? Okay. So we're here, open for discussion, motions.
Make a motion to approve.
Second.
Okay. Any discussion?
Well, and Eric, that was what I was trying to get to with Sally, what is defined as a toddler, you know, and I'd like to ask the applicant or Sally, why didn't we, since we have that in there, why didn't we make it a condition that that is the limit that they can hold, or that they have to hold to?
The city standards only emulate the state code. It's up to the provider to decide what age groups and what mix of children. The maximum of 8 children is what constitutes a small home as opposed to a larger home.
And I
Daycare.
understand that, but we did, I mean, it's in here that that is their intention to take infants and toddlers,
Their intention.
and by the applicant herself, a toddler, once it turns 4, it's not a toddler anymore.
37 months.
Yeah, whatever.
Right.
But since that's their intention to keep that, because, you know, and Joe's right, there's a whole lot of difference between 4 or 5 3-year-olds that are in the house most of the time and a 6, 7, 8-year-old child that's out in the yard.
Staff didn't feel it was necessary to restrict the provider to a certain age group. However, if council feels that is something that should be done, we could ask the applicant. The restrictions that the city has for a small home child care is the total number of children.
I think we should ask.
Yeah.
Any other thoughts? Other than that one? Any other questions while Sally? No? So before we ask the applicant, I think we have a motion and a second. I think, you know, some thought process here as it relates to how we're moving this along from the policy as it relates to this particular application is, I mean, do we really want to go there and restrict the use as it relates to age? I'm not necessarily in favor of that. I think the 8 children is enough restriction in my mind. I think once they start shaving, then they probably have to move out. But anyway, that's how I feel. If you guys feel differently, we can ask the applicant to come up. Bob?
Yeah, I think that there should be more leeway. Basically, once a kid gets kindergarten age, he's gone anyway. So this basically would apply to pre-K. So I wouldn't restrict it to 3. I would say 4 and 5 is fine. But on the other hand, I can also live with the current language, like restricting it to 8 without being too technical about it.
Carol?
I don't, just because the limit is 8 for that particular kind of designation as a small activity versus a large activity doesn't mean 8 children will ever be there. I hope they are for their, you know, I hope you have a successful business. But I think I'm getting the impression that people fear if they're older children there will be more stuff outside, but we have a way of addressing that. If there is stuff outside, as it appears there is at one of the other businesses, we have a means of addressing that with enforcement, code enforcement. So I don't think having babies versus 5-year-olds really is that much of a difference.
What is the pleasure of the council as it relates to, do we want to ask the applicant the question? We do have a motion and a second. We could proceed that way, or the motion maker would have to amend his motion in this case, if he wanted to add that condition.
I'm not sure at this point we can bring the applicant back up. Kim?
Yeah. Yeah. I mean, this is new business. We're not doing any public hearings or, we can have basically whatever process we like, I think.
I'm willing to second Gary's motion.
I think we had a second, but you thirded it.
Oh, okay. We had one already.
John,
I'd like to hear the answer from the applicant.
as it relates to the age.
Age, yes.
Okay. I think we have two. I guess we can ask the question. It won't hurt. Ms. Carter, could you come forward and let us know what your thoughts are as it relates to restricting the age to 36 months and below, or 0 to 36 months is really what we're talking about here.
Well, let's be careful of the math. 0 to 3, so does that go to 3 years, 11 months, and 30 days?
No.
I mean, I just want to.
I think it's 36 months, and then once you hit 36 months in a day, I believe, you're the expert. You're no longer considered a toddler. So,
according to the state regulation in licensing, an infant is from 6 weeks old to a year old, or walking. If the child walks at 11 months old, they are considered a toddler. If they don't walk until they're 13 months old, they're considered an infant. And what we will be doing, and the reason that we are doing infant and toddlers, is because we've had 15 years experience in it. We will be able to keep, according to state regulation, 4 infants from birth to, in the papers, it's from birth until a year old. And then the other 4, we will keep from 3 years old, not over 4 years old, because we do not want to keep older children, school-age children. This will be strictly children under school age, under preschool age, because that's what we choose to do. That's where our experience is. So does that help anybody?
I guess based on that, and I'm just asking the question, I think, for Terry, if I messed it up here, the question that a couple members of council would like an answer to is, would you be willing to accept a condition of approval that would limit the maximum age? So no children over the age of 4 or 5 or 10? I mean, or
no.
You would rather not have a restriction?
No, I'm sorry. You misunderstood me. The number of children, according to the city.
I'm not talking about the number of children. I'm talking about the
age of children.
The question that Mr. Watson raised, or the comment he made, is would we consider putting something as it relates to the maximum age? And so I think a couple council members are interested in that, and
if you can help.
Please state your name for the record.
Nelson.
Your address.
926 Forest Edge Place.
Thank you.
I mean, I think that's something that we could talk about, but I mean, the whole reason that we're doing this age, I mean, just like Mother said, but also it's where the demand is. I mean, you know, when we opened the baby station down there, it's been, I mean, we have a waiting list. I'd have waited, people, when people know they're pregnant, they come and, you know, they reserve spots 9 months out. You know, and actually I still have that daycare center. I have my sister who runs that now because I had a bout with breast cancer, a 2-year bout with breast cancer, and I wasn't able to work, you know, in my business. So I gave that to her. So this is really kind of a spin-off of what I started back in '97. So to answer your question, though, I wouldn't feel 100% good about doing that, just because, I mean, what if somebody comes into town and opens up another infant center? I mean, we were exclusively infant when we opened that. Just for Kids didn't do it. Darlene didn't do it at Preschool in the Pines. At the time, we had Little Hearts. They closed. You know, then the people opened Happy Trails. That didn't work. Bonnie has, Just for Kids has tried to, you know, do infants, which, you know, we're up through 12 months, and it's not really worked real well for her because she's got a bigger, it's not cost effective for her to do that. I'll just put it that way. So, I mean, that's our intent to do, and that's what we want to do. I really wouldn't feel comfortable with Mother, you know, being limited totally to that, though, because if somebody comes in and opens an infant nursery and she needs to keep a 5-year-old child to be able to pay her electric bill or go buy her medicine at Walgreens, I want her to be able to keep a 5-year-old child.
Okay.
I mean, you know, the reason that she's looking at trying to do this is because she's not a real spring chicken, and so but she needs to work. She needs to work some. And my daycare it's our family daycare, I'll put it that way still. She's not capable of working in there. I mean, we've got 15 kids in there, you know, all under 3. So she needs to be able to keep a few in her house that, you know, she can manage. And
So if I could just maybe jump in here,
Yeah.
I think I got the answer, and
Okay.
did that satisfy
Yes.
John and Terry? Or any other questions of the applicant? Otherwise, we have a motion and a second, and I'd like to call the question. Thank you very much for that.
Thank you.
Okay. Cindy?
Thank you. The motion then is to approve the permit for a small home child care to operate at 926 Forest Edge Place, subject to the 7 conditions presented this evening. Smith?
Yes.
Ravetto?
Yes.
Carlson?
Yes.
Harrison?
Yes.
Harvey?
Yes.
Schaefer?
Yes.
Thank you. Motion carries unanimously.
And I'd like to thank the applicant as well as Mr. Watson for coming out tonight. I know this is sometimes a longer process than we'd like, but it's the process we have, and thanks to staff for always doing a good job. So with that, we're going to move on to 10B. That's reviewing the budget. And David, I think you're going to kick us off, aren't you?
Thank you, Mayor Pro Tem. Yes, I am. Council will recall that at the last meeting, we had a spirited discussion on the general fund, the grant funds. We deferred the DDA fund discussion till this evening, as well as the enterprise funds. I'm happy to report that Councilman Carlson and I and Kelly Case spent a little over an hour today going over that portion of the budget that we reviewed last week. Council has received some updated papers from us over the last couple of days, both electronically and in hard copy, because we've had some impacts to the budget that are worth bringing to your attention. Specifically, we have received some of the development fees from Womack Ministries that had quite a large impact on water and wastewater, not necessarily for the 2013 budget, but for the 2012 budget. We projected what we expected those revenue streams to be, and in several of those cases, they were less than what we projected. There was an initial thought that the service line to Womack would be a 3-inch line. It's actually going to be a 2-inch line. So those projections were a bit more than what our actual receipts were. Conversely, the transportation capital fees were a little bit higher than what we had projected. So those numbers are now included in the updated budget sheets that you have. They have not filtered their way back into the budget message. There's a chance that we're still going to have some minor changes, and I'll update that budget message at the very end to reflect what those final numbers are. So the updates that reflect the Womack Ministries revenue stream don't have an adverse impact on the budget. And again, it was the 2012 component, not the 2013 component. So we've got those to you. You'll get them inserted into your books, and we'll move along with the budget presentation. As I mentioned tonight, we're going to talk about the DDA budget, both the operational budget and the debt service budget. Joining us this evening from the DDA is Chairman Dale Schnitker and Board Member Jan Kummer. And, of course, Kelly is here to help with some of the details if I fail to answer your questions. Once we finish the DDA discussion, Kip Wiley, as the Utilities Director, will walk through the enterprise funds, both water and wastewater. And then, of course, we are prepared to answer any questions you may have as it relates to other areas of the budget that we discussed at the previous meeting, general fund, grants, etc. So with that, I'd like to move into the DDA budget. And I would like to call your attention, please, to page S, as in Sam. This is the DDA budget summary for the operational component. We're going to talk about the debt service component in just a few seconds. There was a lengthy discussion in the budget message on the uniqueness of this year's DDA budget based on the fact that we have a project in place now at the in the Woodland Station. So there's been a sale of land that has caused the revenue stream to increase for the DDA budget. We also have a reflection of some of the expenditures associated with that fund as well. As we move through the summary, you'll note about the fifth line down, projected unrestricted fund balance for year-end 2012. You'll note that that is significantly improved over previous years, and that's due to the sale of that land. What I'll tell you is that some of those savings or some of the additional funding there is being kept as a contingency, as a reserve for the Woodland Station project itself. That should we not have to use any of those contingency funds, and those savings will propagate through, so that by the end of year 2013, you will see that we have the smallest negative number that we've had in some years associated with the DDA budget. And I think you all understand those implications. That is covered then by that $1 million loan from the City General Fund some years ago. So from an operational perspective, very little has changed, and we'll talk about the details associated with that the DDA budget right now. So if you'll turn to the tab that's 215 DDA Fund, which is on page 25. You'll see that the revenue stream is as it has been in the past. There's a TIF revenue generation from the property tax, and you can see that is slightly down from last year. We also have some of the TIF repayment from some of the districts that weren't made in years past, and so that's being caught up. And then, of course, we're projecting that we'll make a whopping $50 on interest on the funds that are currently in the bank for the DDA revenue stream. If you'll flip the page to page 26, it's the DDA operational expenditure funds. Very little has changed from last year. And I or Kelly or Dale could answer any questions that you may have about the DDA operational fund. So at this point, should you have questions on the summary, on the revenues, or the expenditures, we'll do our best to answer them. Councilmember Harvey had 4 questions that she sent to me yesterday. I provided those responses via email late this afternoon, and plus you have a hard copy at your places. So if you have questions on those, we're prepared to answer them or review those.
Questions as it relates to the 215 fund?
One question I have now, and I'll develop the thought on this as we get to the actual approval of the total budget, is if we were to address the fact that some of our other taxing districts are losing revenue because of the DDA process, for instance, Teller Fire District, if we wanted to somehow compensate them for that amount of money that they lose, is there any margin within this budget that would allow us to do that?
No, I don't think so. But I want to comment on one of the statements that you made about the other taxing districts losing dollars. They're not losing dollars. They might be losing potential dollars.
Yes.
So I think, but that's a clear distinction that needs to be made, because many people think that the DDA is robbing the other taxing districts, and that's just not true. If there is an increase in what the DDA has the potential to receive, then those other taxing districts would not be receiving that. So if a development were to occur outside of the DDA, then it is true, the other taxing entities would be, would receive their full mill levy proportion, and they don't receive that with the DDA. The DDA has taken some steps to help that situation by modifying the rules as it relates to new inclusions, and that then there would be, and that was adopted by the DDA, so that if there were a new entity, a new area that came into the DDA, then the DDA would want to work with those taxing districts, the library district, the fire district, ambulance service, et cetera, to try to make them as whole as they possibly could. They have not made that retroactive to the existing DDA.
Okay, so that will in fact occur for new inclusions in the DDA.
That was adopted by DDA resolution probably 8 or 9 months ago.
Okay.
That's correct on that. So we could have the latitude
Dale?
to make those.
Dale? Sorry, I keep getting kicked when people talk from out there. Can you state your name and address? For
Dale Schnitger, 1361 Pinion Ridge Court. In regards to that, we had actually had this discussion several years back in regards to the different entities and what this would do to their budgeting and the different incomes that they would have. So we put that in process, not as a standard, but each inclusion, if that would be, the last inclusion that we had, that we'd have the opportunity to figure out how to make them as whole as we could as the process went through. So we have addressed that, and that will take place.
It will take place. It is not taking place, for instance, with the Woodland Hardware.
With the Woodland Hardware, the issue that we have there is because of the debt service coverage that we have on there, and the appropriation of funds, the amount of money that we need to put in that infrastructure, the opportunity to have additional funds is not there right now.
Plus, that was not a new addition to
Right.
the DDA.
Okay.
The process that the board adopted was for new inclusions into the DDA district.
Will it include Councilman Smith's project?
Yes.
It will.
Yes, it will.
Yeah, and we'll have to see how next Tuesday goes, but, obviously, we supported via resolution the mill levy increase for the fire district, and if that passes, then, I would have hoped that the fire district took into account what they needed. I know we discussed that last time, and hopefully they are asking for enough mill levy to make them much healthier financially.
Yeah. But that has been a concern of ours too, so
Thanks, Dale.
thank you.
Other questions, Terry?
Well, and I never thought of that before. The DDA is a district, and as Dell stated, they've got some mechanism or tool in place to where they can help the fire district or whatever. However, if there was other districts that had a surplus for whatever reason, the library district, for instance, the library district would have the ability to, would they be able to take those funds and spend them, give them to the fire district? But it's,
I think that would.
it's just a question.
I think that
possible.
I think that would all depend on what their district, the legal documents that form the district and whatnot, whether they could do that or not. But that's another interesting. Not to belabor, but the library district doesn't pay any property taxes, but yet they still get fire service. So. We could take this a long ways.
Oh, yeah.
The city doesn't pay any taxes, but yeah, we have fire service. So, there are a lot of entities.
But we furnish the water.
We hope so.
For the fire.
So, are there other questions as it relates to the budget item for 215 and?
It is what it is.
It is what it is.
I just
Bob?
Well, several years ago, kind of lit a fire underneath the DDA.
We shouldn't use fire
Oh,
and
okay.
DDA in the same. Sorry.
That we need to see some results in return for continued budgeting and funding of the DDA, and that resulted in the 3 projects this last year. Are we satisfied with that, or should we have other milestones we need to set? Because what we got so far really isn't paying the bills. I don't see any way we're going to get that $1 million back unless there's more progress on selling more properties and doing more development. So that was one of my concerns is, do we still have an ongoing review of the business case for keeping a DDA in conjunction with just say, oh yeah, we know you need these people and you need this much for copy paper. But it's the bigger principle of, are they still on the hook to prove themselves?
Well, and I think we can have a long philosophical discussion as it relates to the DDA, and we have since I've been on council, and Terry's could probably talk about a lot of different war stories. One thought I have is, we've been through a tremendous economic boom, bust, and, we can set all the goals in the world that we want and have all the dreams, but until the free market comes and says, I want to do this here, we're not going to generate any more tax revenue or hit any targets. That said, I think it's very positive in my mind that we have 3 projects that are underway, under construction. I think that's great. And I think activity in the community is picking up. I think the DDA still serves a very valid purpose, and that is to create an economic incentive to hopefully bring folks to the community and make investments. That is the only tool we have in this community. So I know it's gotten a bad rap, and I know that it's not always, we'd love to see the shiny stuff built and the money repaid and whatnot, but we've made an investment as a community, and I'd hate to see us react when I think things are finally starting to happen and see us go away from that. Gary had a thought or a comment, and then Carol will come back to you.
The letter that Dave sent to Carol, number 3. How much did the city lend to DDA? Were there any special conditions with his loan? Well, I understand, it said 2007, we lent DDA $1 million, Dave, at an interest rate of 4% to a certain date, and then that was amended on June 7th, 2011. Interest was changed to 1% at the end of that point in time. But the thing I have a question on is that plus interest accrued as of June 7th, 2011, $160,000 to make an amount due on date of maturity of August 1st, 2013 of $1,160,000 plus accrued interest at 1% per year simple interest. Well, does that mean we're going to get the money in 2013 on August 1st?
That's what this says.
Yep.
Realistically, I would tell you that's probably not going to happen. And that's what happened also in 2011 when we extended the loan. So
if it doesn't happen, and if it goes on infinitum, is there a point at which we write this loan off, or what?
That would certainly be council's option
Which
to
means
do that.
we essentially lost $1 million.
Well, and again, in the larger discussion of the DDA, that recall that our DDA is driven by property tax, not sales tax. So those things that are built in the DDA may not pay the city back through the property tax, but they might through the sales tax. I'm not professing that that's the way you should think about it, but it is a way to think about it. But what I would also suggest to you is that just as we renegotiated the timeline in 2011, you'll have an opportunity to do that in 2013. Remember that one of the other questions was, what's the life of the DDA?
Yeah.
Well, right now it goes to 2032, and then you saw the other answers as well as it relates to the debt. I can tell you that the DDA board has the full intention of paying that debt back, and I think that they're showing finally the ability to make some progress associated with that. So what I would tell you is that...
So that maturity date means nothing.
Well, it does mean something. It means that it's another checkpoint for the council to make a decision as it relates to the DDA.
Yeah, most commercial loans have a very short period of time associated with them. So that's not, in the world of finance, that's not unusual. Carol, you had a comment?
And I certainly don't come from the world of finance, and that's why I'd posed these questions to David so I could kind of understand what our options were. And I've begun to look at the DDA as kind of like the college student who comes home to live in your basement, and you co-sign the loan with them, and you know if you kick them out, you're never going to get it back.
That's pretty good.
I think that's where we are with the DDA. Yeah, they've got promise.
And that's just like your college student. The college student has promise, and so you're betting on their future, and that's what we've done. It's a reasonable bet, if you will, in my opinion, for the development of the downtown area for the benefit of the whole community. But you're right, it's a bet.
Bob?
Just a question on page L, down at the bottom, we show a fund balance non-dispensable due from DDA as an asset of $1 million. Shouldn't we include into that the interest that they owe us also?
Yeah, that's a question that gets asked every year, and it has to do with the accrued interest, and it's the generally accepted accounting principle process that Kelly is brilliant at. You're on, Kelly.
Thank you, David. As a governmental type fund, it is not proper to account for things as a business enterprise would account for things, similar to the 510 and 520 enterprise funds. The balance sheet does show the principal amount, but the accrual of the interest liability is not booked to the balance sheet, and that is GAAP accounting.
Okay.
So
I'm going to try to remember that for next year, because every year that question's asked, and I
And
don't
you
remember
can
the
answer it next year.
Okay. Better take notes.
So it's an asset that has potential for decreasing value.
It's
Doesn't
actually
get paid.
It's an asset on the books as a receivable on the general fund because they loaned the money, and it's a liability on the DDA's side of the balance sheet because it's owed.
So we have a note, and that note is the asset.
Right.
So.
Correct.
David or Kelly, we did receive at least one payment, I think, from the DDA, didn't we?
No.
We budgeted to.
In 2012, the DDA board hoped to begin some payment back, and it was a minor amount. It was a token payment of $5,000. As we moved through the process of bringing Woodland Station out of the ground, there were some issues with the contract, as we've discussed last meeting, and so that $5,000 payment has not been made. But we've still got a couple of months left in this year. Honestly, I don't know if that payment's going to be made or not. But that was the intent of the board.
Okay. Well, I wasn't sure if it was paid or if
No.
they were just hoping to be able to do that.
Other questions on the 215 fund? Otherwise, we're going to move on to the 305 fund, which is the debt service fund. Bob?
It's probably worthwhile asking every year, too, is what's the assessed value of that land?
Well, the assessed value is of the district in its entirety. Individual parcels, that information is not available to us. It is available to the property owner. But asking the assessor's office for individual property valuations other than what's disclosed, I mean, there is a valuation, but, I mean, you can distinguish, there's a portion of it that's base, and that was established back when the TIF came into existence. And the value of that parcel on the date that the district came into existence is what we call the base of the property. And then anything that grows or accrues or even goes below that base is the TIF. That's the increment that those revenues are interrupted and go to the DDA for the 20-year life of the DDA. So to find the two components of that assessed valuation for any particular parcel, and I assume you're asking about the Woodland Station parcel, or am I
I'm
wrong?
looking at the former rodeo grounds, that part.
And to distinguish between those two components of that, we have not been able to get an answer to that question from the assessor's office. The total valuation of that parcel, I don't have off the top of my head, but we can certainly look it up on the Teller County website.
But if we had a developer come in and say, I'll give you $2 million for that property, we'd be able to say, hey, that's a good deal or that's a bad deal.
Yeah,
That would be determined by the DDA, would it?
It's an appraisal process.
Yeah, I mean, I think,
Yes.
to get a valid value every year, we would have to do an appraisal.
Every year.
And that would run $4,000 to $5,000 and take 45 days and to go through that process. I don't think that that's necessary.
At
I
this
mean,
stage.
the ground is worth what people are willing to pay for it, and we've had one owner come forward and paid a certain amount for the land, and we could apply the same square foot cost across all of it if we wanted to and come up with some number, but that number is only valid till the next person comes in and makes the next offer, and the DDA either accepts it or doesn't.
Okay.
And I can tell you in the financial statements that you're in 2011, that land, as it's carried on the books as an asset of the DDA, was adjusted based upon that square footage price for that offer for the land that was recently sold.
That's where the information came from.
That's correct.
Because it's been going down and down and down.
Well, that was the first adjustment down that we'd seen, was in 2011, because we had a comparable or something that was relevant for us to give us a current market value per square foot. And that was applied to the remaining land in that parcel that still belonged to the DDA after that sale would close.
Okay.
So that's what that write-down was.
Okay.
One other thing I would offer from a real estate perspective is with the improvements that are occurring, we're getting to more pad-ready sites, and that makes the value of those go way up. So the difference in raw ground and what that might sell for versus a pad-ready site, for instance, where Nth went, that sold for $14.50 a square foot, I believe, but that was pad-ready. And so, it's kind of a moving target as you're developing it. So I would hope that going forward, future properties in there would actually sell for more for all those reasons.
And they'll be market-driven.
Right.
But that was kind of behind my concern too, is when we loaned them $1 million, it was to improve, in a sense, get in the direction of making it pad-ready, improve the assessed value of that property. If instead we used it to pay salaries or something like that, then that would have been, in a sense, wasted money, so. Yeah.
I guess, is that something you
Well,
want to address?
the intent of the loan was to absolutely move forward with, but it was intended for the design effort and operational effort. There was nothing associated with that loan that was for construction. So your statement is only true for making it pad ready in the sense of preparing the plans to help make it pad ready.
Any other?
Was that design for the civil works associated with that, or was that design for the previous $50 million scheme that has been shot down?
I don't know if it was the $50 million scheme, but it was absolutely for previous iterations of design. It's true, and there's a huge portion of that was able, well, I shouldn't say huge. There was a portion of that was able to be transferred to the design that's being executed now.
So, bottom line, though, is a lot of that design cost went to waste because we're using maybe the civil works part of it, but as far as structures and stuff, that's lost.
Well, I would agree that it's lost. I wouldn't say it was wasted because it was part of the development process, and I would suggest to you that developers have numerous iterations of design, and I don't know that they would say that that money's lost. It's part of the development process.
If you'd ask if that ground over there was dense, I could probably show you a spot or two that was at the time.
Any other questions as it relates to 215? Otherwise, we'll move on to 305.
The DDA debt service on page 27 is, as all of our debt service accounts are, they're basically a reflection of an in and out account. This debt service goes to pay the debt to Vectra Bank, for that loan, and you'll see that the revenue stream that comes from the operational component of the DDA budget absolutely matches the expenses on the next page. So this one's fairly simple.
Any questions on that one? All right.
And so if there are no other questions about the DDA budget, then we'll move forward to the enterprise funds. Are there questions on the DDA budget before we do that?
Or any other general burning questions on the DDA that we haven't covered?
Okay. Dale, thank you. Jan, thank you. So we'll turn the enterprise fund discussion over to Kip Wiley.
Thanks, David. I'll first briefly go over the water and then wastewater. So the water enterprise, the 510, do a budget message recap, and go through the budget summary, and then go on to the line items for each enterprise. If you please turn to page G of the budget message. The water enterprise is in a stable operating situation and has continued to do so through 2013. There is no major projects scheduled for 2013. The largest share of the current annual debt will be paid off in 2015, and when substantial TAP revenues come back in, or when that debt service is paid off, we can look at our local augmentation reservoir projects and other needs that arise. With that said, can you please turn to page Z of the budget summary? Second line down for 2012 projected revenues, and the fourth line down, the 2012 projected expenditures. You can see that the revenues were greater than expenditures, giving us an increase in net assets for 2012. Moving to 2013, net assets, or I'm sorry, budgeted revenues compared to expenditures. Revenues are less than expenditures, therefore decreasing net assets by about $40,000 compared to the previous year. This is due to the debt service, and that, like I said, will be paid off in 2015. Any questions on the budget summary? All right. If we could then switch to tab 510, the Water Enterprise Fund, and we can go through the line items. That is page 37. That's projected revenues for water operations, water capital, and water rights. Can I answer any questions on page 37?
Are there any questions that council has? I assume that the water, well, maybe it's, as it relates to taps, the last several years we have not raised tap fees.
Correct.
Because of the current economic conditions, plus, you know, when you're only selling 5 taps, it's kind of a de minimis amount. But was the number that you selected based on the thought that you'd hold taps fees constant for 2013, and that'd be the recommendation that you'll bring forward to council, or?
Yes.
Yep.
Yep.
Okay.
Same number of taps. Actually, we've actually sold 8 taps. Another one, a single family, just came in. It was just a water tap, not a water and wastewater, but 7 single family equivalents, or a tier 2 tap would be budgeted for 2013.
Wonderful.
It really is. That's what, 5 more than last year?
It's more.
Yeah.
Bob?
We have a council liaison to the Water Enterprise Fund Board, I understand.
We have 2, Mayor Turley and myself.
Okay. Have you reviewed this budget before it was put in, or? I mean, I like to have somebody that has a special expertise in this develop, say, hey, this is good, and then I can just believe you.
Yeah, we don't, as part of the board, we don't really get into the budget too much. We do talk about priorities and, you know, what we might look at to do in the future as it relates to some of our infrastructure needs, and talk about tap fees and more broader issues. We don't really drill down, at least I don't remember drilling down on budget too much.
The only, I would say it's a Utilities Advisory Committee is the name of the group, and they're not the board of directors for the enterprise fund.
Okay.
They're an advisory committee, so they're a technical advisory committee. They do review with the utilities director projects that might come forward in the future, capital projects, to understand that. And from that perspective, they do get involved with the budget, but they don't review whether or not we're buying the right amount of chloride or paper clips or things like that.
Right.
But they are involved in visioning for, say, capital projects.
Right. And I would hope, too, they're interested in whether or not we're going to have to raise fees or not, or potentially after you pay off all the bonds, reduce fees.
And I think all of that is part and parcel to what David had mentioned as it relates to, you know, I mean, I would encourage, depending upon if you have an interest, our water system and water in Colorado in general in the West is very complex. And understanding how we get our water, where we get our drinking water from, how we augment, what the issues are, that the weak links in the system, so to speak. And one of the things that I've pushed hard on has been a local reservoir, because that is the weakest link in our system. And so that's a balance, obviously, and really that's what we get to decide as council as it relates to the budget is, you know, are we going to budget for a reservoir that's going to cost $4 or $5 million? And, you know, when we pay off one set of debt, do we want to go into debt again? So.
But I didn't propose to be an expert in this subject. That's why I asked their initial question. Do we have people that I can rely on?
We do have an expert. I think he's sitting there at the end, and he knows more about this than any of us will ever understand, I'm sure, probably.
Currently, we operate with water. If we don't sell any taps, or very many, net assets do decrease. But that's also, like I said, taps bring that balance back up. Your comment to, you know, if we're making too much money, decrease fees, or if we need to build a reservoir and we need to increase fees, there's a fine line there that has to be looked at all the time.
Okay.
Other questions related to, I guess, page 37, and then we can kind of start flipping through this. Okay.
Page
38.
Yeah, real quick. KIP top line 1,100. Last year was 106,209. This year it's what, $22,000 smaller on salaries, wages.
That'd be the new utilities director.
The parenthetic statement there in that line says that you're paying him a lot less than you paid the previous guy.
That's almost unfair.
He'll eventually get up there, though.
Lots of experience to be gained yet.
So by hiring you, we're saving money.
In a sense.
Yeah.
A lot of sense. A lot of sense.
Well, that's a tough question to answer.
Thanks for pointing that out.
Kip, I'm sorry.
We appreciate
Next time I walk by your office, you can throw something at me.
We appreciate your desire to have a positive impact on the budget.
Can we move on to the next page?
Any other questions related to page 38? Moving to page 39. You know, and that's a interesting. In years past, I don't think we had all of the things in parentheses.
All the notes.
All the notes, and so that has been helpful, and so I appreciate that. And I think, Terry, you and I have to get used to looking at those little things, you know, My eyesight's getting to the point I can't see something that small.
This is my last one, buddy.
Well, you're done. Okay. Nothing on 39. We'll go to page 40. If there's nothing on 40, we'll go to 41. See, we're spending less on legal services. I guess that's
Yep.
for some.
Wrapping up a couple cases.
Oh, that's true.
Didn't have to go to trial.
That's right. Page 42. Page 43. And if there's nothing else, we'll move on to 520. So are there any other comments as it relates to the 510 fund? Okay. Kip, we'll move on to the 520 fund, wastewater.
Wastewater, 520. I'll recap the budget message, then go through the budget summary, and then on to the line items. For the wastewater enterprise fund, it's a very healthy and in operations and in stable condition. Unfortunately, we're in need of a plant upgrade due to our organic loading, and with the last couple years of slow growth, we've been able to postpone that and do an evaluation of the plant to maybe even try to get it re-rated to an higher organic loading before we have to do a phased approach of expanding for wastewater. With that said, can you turn to page AA in the budget summary? AA in the budget message. It's the wastewater budget summary.
It's the last page of the budget message section.
You'll see projected revenues for 12 were again larger than expenditures in 2012. That was partly due to the WAMAC tap fees. Same scenario here as in water. The 2013 revenues and expenditures. Expenditures exceed revenues, and this is due to the FEMA project for Fountain Creek. There's an additional $100K contribution from wastewater in that project. Any questions on the budget summary?
Any questions? I guess we'll flip to the, I'm sorry, Bob.
Comment. During our goals and objectives meeting, Gary brought up the idea of maybe that the Europeans are using to recycle some of the waste that comes out of that waste stream and create energy or something like that. Is that something that's going to be addressed this year or by the advisory committee in the future? What's the idea on that?
The intent is that we can do some investigations in 2013 at no cost, so there isn't a budget implication. And so in the summary on page I, in the budget message, the very last one was what I referred to as wastewater treatment plant greening. That at this point we think we can get lots of information without investing any money.
Right. In that line, I was sitting at the Auckland airport talking to someone, and he turned out to be representative of the company that does this. Okay, and so he's going to be sending a whole bunch of information. So take advantage of these little networking opportunities. So
perfect.
I'd like just to make a little note to wrap up the budget summary. In 2013, majority of the debt service will be paid off in wastewater.
I think we're at a very interesting time in the city of Woodland Park's history as it relates to debt. There's a lot of debt that's being paid off in the next few years from streets to water to sewer, and so it's actually a very good time. And I also think that our infrastructure is still in very good shape. Yes, we have to make some improvements to the wastewater treatment plant, but we're fortunate that we still have good infrastructure in place. It's new, and we have money to continue to invest in our infrastructure. So,
thank you.
So moving on to the 520 tab.
520 tab, page 44. Projected revenues. Can I answer any questions on that page?
Any questions? We'll move on to 45. Any questions here? Terry, you want to ask the same question there?
No.
Okay.
He's too good a friend.
Okay, page 46.
Could ask them why they didn't make the parentheses bigger.
I'm with you.
I did that on purpose. Just for you, Terry, your last budget.
Any
You're a
questions
good
on,
friend too, Kelly.
any questions on page 46? Page 47. Any questions? Page 48. And finally, page 49. I think that wraps up our review of the budget on a line item by line item basis. I guess at this point in time, I don't know if there are any general questions or comments. Maybe before we do that, if David, you could explain how we will go forward between now and approval of the budget, and will there be additional discussion opportunities prior to approving the budget?
I'd be happy to. Per the budget calendar that's included in your budget message, we will bring to you at the next meeting, the November 15th meeting, the first reading of the budget. Plus, what we also bring to you is the resolution certifying the mill levy that we use. It's not changed since 1991. We have no intention of proposing a change for 2013. But that's a resolution. It's not done by ordinance. If there was a change, there would have to be a completely different process. But to keep it the same, we do it by resolution. So on the 15th, we will have the first reading, and we can have as much discussion on the budget as you desire. Our intent is to have the public hearing and the final reading of the budget appropriation ordinance on December 5th. Remember, my motivator for you is that we get the budget done on December 5th. Then historically, we've canceled the second meeting in December. So that motivation is still there. So we're prepared tonight to answer any questions that you have about any component of the budget. All department heads are here with the exception of the police chief, and we're prepared to answer those questions if you have any. So we're not trying to hinder any discussion, but we're standing by for your questions as it relates to any component of the budget, should you have them.
Any questions? No?
David, may I ask that if there's any changes that the council has in mind for the budget as it stands now, I intend to prepare the appropriation ordinance according to this document that you see. And if there's any direction for change, I'm happy to take that at this point.
I guess not.
I guess not.
Yeah.
Thank you.
Okay, thanks for your indulgence this evening.
And while we're not through the budget process yet, because we haven't obviously moved forward with our voting, I will say that I think this went very smoothly on the line-by-line basis, and want to thank staff for always doing a tremendous job and conveying what is a lot of information and a lot of nuances and little things. One year we had a big discussion on healthcare that took up a lot of time, and so I'm very happy that it's proceeded as it has, and I guess everyone is satisfied. The new council members that are going through this for the first time, I can remember the first time I went through this, it was overwhelming. So anyway, so thank you. Okay, moving on. The next item on the agenda is public comment on items not on the agenda. We don't have anyone signed up, but there's a number of folks in the audience, and we'll start with Debbie, if that's okay. I think I saw her hand first.
Thank you, Mayor Pro Tem Smith. I wanted to come tonight and personally invite you all to attend next week is our Fall Business Expo. We actually moved it. It typically is the same night as City Council, which really puts trouble and a hardship for you all to be able to come and attend. It will be at the Ute Pass Cultural Center. That's on November 8th from 5 to 7. We'll have 38 businesses there. Some of them are new businesses in the community, some are home-based businesses, others have brick and mortar. But we urge you to come and experience and get to know these business owners on a personal basis and get to talk to them. And so we wanted to come forward tonight and invite you all to come and visit. It's free to attend. There will be food and a cash bar.
Thank you. Come on up.
Thank you, Eric. My name is Steve Gerislow. I know several of you on a personal basis. I'm familiar with several others with regard to other organizations that I'm a part of. You'll be pleased to note that I am not going to speak to you tonight about either babies or budgets, but rather something much more fun, which is a ball, and specifically a sweetheart ball that's sponsored by Help the Needy, a local nonprofit. Before I get into that, and the event is scheduled for February 9th, 2013, as shown in what Cindy is handing around to you. But before I get into that, I did want to explain to you what Help the Needy is and what it does, since some of you might not possibly be familiar with the organization, and I will be quite brief. Help the Needy is a 501c3 nonprofit organization here in Woodland Park. And it has been around for over 30 years. It was founded originally by a fellow by the name of Greg Schilling, an individual who operated out of his own home using his own funds. Since then, the organization has grown to about 120 volunteers, if you include the woodcutting crew, and it has its own building at the corner of Henrietta and Center, just a block from here. It is a very robust organization. And what it does is provide temporary financial assistance to families in need here in Greater Teller County to cover things such as utility bills so that the utilities aren't cut off, payments for medical expenses that they couldn't otherwise afford, payment for their children's glasses because the family might not have the money for that, payment for gasoline for their vehicle so they can commute to their job in Colorado Springs, payment for automobile repairs. In addition, firewood supplies. We actually provide families with delivered, cut, and split firewood right to their door during these winter months from September through May. And I can tell you, I personally have made one delivery. I only have a Highlander, so I couldn't include a whole lot of firewood, but another fellow and I delivered firewood to a family, a destitute family in Cripple Creek. It was a grandmother and grandfather and their granddaughter who'd been abandoned by their parents. They just left Cripple Creek with their baby homeless. The grandparents took the daughter in. They lived in a 110-year-old shack with no insulation anywhere. They had no furnace and no money for a furnace. The only source of heat they had was the wood we were delivering to them, and we kept them warm all winter. And we do things like this routinely every single business day here in Teller County. We are all volunteers, as I said before. Not one of us gets paid a penny, right from the executive director, the board of directors, on down. To give you some idea of the kind of benefits we have provided, or the numbers, I should say, the statistics that we have, our busiest year, as you would expect, was in 2010, at the height of the recession. We serviced 451 clients here in Teller County, which actually included, since these are 451 families, it covered 750 adults and 434 needy children, for a total of 1,200 people approximately served by Help the Needy. The figures for 2011 were 368 clients. Thus far this year, we have 218 clients servicing a total of 578 people. So it's quite a wide swath of people who we do help every year who have, in many cases, nowhere else to turn. We do, however, partner with many other organizations, nonprofits here in Teller County, such as the Aspen Mine Center, the Community Cupboard, the Teller Senior Coalition, the Pikes Peak Workforce Center. We also provide budgeting assistance to people, some form of legal referrals as well. So we try to leverage off of all the other nonprofits in Teller County to provide the maximum benefit for these needy families. The net profits from all of our fundraisers, including the Sweetheart Ball, all go, with the exception of office supplies, right into the hands of our families. So no one's making any money off of this. As I said, there are no salaries. So with that as a foundation, I would like to extend an invitation to each and every one of you and your significant others to attend the Sweetheart Ball. It's the Saturday before Valentine's Day, February 9th, 2013. We are holding it again at the Shining Mountain Golf Course edition. If you haven't had an opportunity to go there, I recommend you do. I think you'll be really surprised and pleased that Woodland Park has such a beautiful venue. It's well run and well decorated. Actually, we do a good job of enhancing that on Valentine's Day or right before Valentine's Day, along with some beautiful decorations on the tables. But one of our big selling points this year is Swiss Chalet is providing the dinner. And I think most of us would likely agree that Swiss Chalet is probably the premier restaurant in all of Teller County. Neil Levy has been extraordinarily generous with us, and he's helping us out with many details. The dancing band, we will have dancing, is provided by the John Carey Dance Band. We also hope to have dinner music. We have 2 auctions, a silent and a live auction. And let me tell you, ladies and gentlemen, this is not a $10 gift certificate to Burger King. Let me just give you an idea of some of the auction items that we had last year, and hopefully we'll be able to duplicate that again this year. We had not 1, not 2, but 3 one-week paid stays in townhomes in Hawaii, North America, and the Caribbean to bid on. And they all went. Every one of them was bid up. We have major works of art from local artists. Neil is going to help arrange for us to have a 12 certificate package to the finest restaurants in El Paso and Teller County together to bid on. So these are items you do want to bid on. My wife and I, we've gone to 2 of the last 3 balls. We typically bid on 5 or 6 items and typically walk away with 3 or 4 of them. Many of these items can be bid at less than retail. Some of them, because of the enthusiasm of the attendees, end up going for retail or even more. It is a truly magical evening. It is one of those rare opportunities any of us has to dress up in other than this, dungarees, jeans. The women tend to wear cocktail dresses, pantsuits. Some of them wear evening gowns. The men tend to dress in jacket and tie, business suit. A couple of tuxedos last year were seen. It is couched as semi-formal, but it's slowly morphing, I guess, into a somewhat formal affair. I would argue, I think convincingly, that it is the signature social event in all of Teller County every year. We have valet service, coach-check service. We're having cadets from the Air Force Academy being maitre d's. It is a classy, classy event. It's not only a place to be and enjoy yourself, it's a place to be seen. You will see some of the best-known businessmen and women of our community, presidents of banks. The Cripple Creek and Victor Mine has already reserved their table. The hospital has already reserved their table. I know we're going to get a lot of doctors, dentists, lawyers, CPAs, and plain old-fashioned business people to attend. Every year we end up attracting close to 200 attendees. We fill the house. So I would like to invite each of you to attend. I would urge you to attend. I would urge you to put yourself down for a ticket or 2 or more sooner rather than later to make sure to reserve your seat and your table. And there is information on the Save the Date card that you have. On the back of it, it does talk about reserving an entire table, which is 8 guests. Could be single folks, married folks, girlfriend, boyfriend, whatever. It doesn't matter. 8 guests. It is $50 a ticket. But for an extra $100 for all 8 people, for a total of $500, you can reserve the table, you get your name on the table, you get your name in as a corporate sponsor on the program, which is not inconsequential, and you get a free bottle of white wine and red wine as well for that extra $100. So I would like to again extend a personal invitation to each of you and your friends, your neighbors, your relatives. It's going to be another gala event, and I'm looking forward to seeing at least some of you there. And thank you, Cindy, for the opportunity to talk. I appreciate it.
Steve, thank you so much. I mean, your organization obviously does a lot of great things, and to be commended, all of the support and the volunteers. I'm sure all of us here know people that have been helped by your organization. I do, and I think your organization just does great things. And I think they sent the right person here to sell us on why we need to come, and so thank you. You did a great job. So
thanks very much. I
any
appreciate
other comments
it.
from anyone else you want to make? Okay.
Thanks very much. I
Thank
appreciate
you
it.
for coming tonight.
Thank you.
Thank you, Steve. Okay. Any other public comment? I know it's hard to follow him, Steve. So, okay, moving on. So under reports, I've got a few items here to read off, and then we'll go to council reports. So these are upcoming events next week, November 2nd through the 15th. So on Friday, November 2nd and Saturday, November 3rd, the Rocky Mountain Christmas Boutique at the Ute Pass Cultural Center, noon to 7 p.m. on Friday, 9 a.m. to 4 p.m. on Saturday. The proceeds from the benefit go to Choices Pregnancy Center. Of course, I think we all have this circled, and that is the general election, which is Tuesday, November 6th. So hopefully everyone will turn out and vote. I think early voting goes through tomorrow. That's correct. So if you don't want to go stand in line, you can, and you haven't voted yet, you could go tomorrow and vote at the library. Saturday, November 10th, the Winter Farmers Market, Ute Pass Cultural Center, from 9 a.m. to 2 p.m. Saturday, November 10th and Sunday, November 11th, Mountain Holiday Arts and Crafts Festival, High School Commons, 9 a.m. to 5 p.m. on Saturday and 10 a.m. to 3 p.m. on Sunday. Sunday, November 11th, is Veterans Day Recognition Ceremony at the Cristola Roadhouse, 12 noon sharp, followed by lunch. So those are the upcoming events in our community. Any council reports? Gary? No? Bob?
You all recall we had a workshop for the Aquatic Center. That was to start the process of the discussion between the board and city council. And so at the following board meeting, we agreed to a motion to try to initiate that follow-on meeting. Whether it's one or more, I don't know. But trying to find out what days are good for city council. I know that's pretty hard to decide. Otherwise, we'll just pick a date and see how many people can show up. But if anybody has a preference of not to meet, maybe that would be the easiest, because we would like to set up that follow-on meeting and answer people's concerns.
What would the objective be for that meeting, Bob?
To answer remaining questions. There were a lot of questions raised in that workshop, and including scope. I think financing, until we finish the budget process, we can't really nail that down. So it'd be more related to scope, acquisition strategy, that sort of thing.
Okay.
Any thoughts or comments from council on Bob's?
Well, are you talking about possibly a work session prior to a meeting?
We can have it either prior to a meeting. I think we probably need more time than we did last time. That was a little frustrating to try to get everything done in 1 hour. So a separate evening would probably work out better as far as making time available for a full discussion.
it's council's direction, we can certainly, from a staff perspective, try to facilitate that scheduling if that's what you'd like for us to do, rather than try to get it done here tonight.
Right.
Please.
If that's your desire, we can.
Yes.
I do have one question. Is it the intent, Bob, then to have this meeting before the budget process is finished, or is?
Well, like
does
I
that
just
matter?
mentioned, it was not related to financing necessarily at this stage, although if people want to raise that, they can. But it was more as to the scope, how we're going about making sure that the scope meets the community's needs. And there's, perhaps council may have some concerns about the scope too.
Okay, we'll get that.
Location would be another one, for instance. There were some questions raised about location. So
We'll take the lead on trying to get that scheduled.
Thank you. I attended the Colorado Municipal League Policy Committee meeting on the 19th of October, and I had the notes from that sent to all of you this afternoon. Large group, I think it was a record group, and for those of you who may not be familiar with the work of the league, they are really the lobbyist group for small towns and municipalities in terms of legislation, policy, regulation, a very, I think, a diversified group that represents our issues very well at the state capitol. There were a couple of different issues that were considered, but one of them that I have meant to get back to you with, Aaron, is the committee voted to allow CML to initiate and support legislation for increasing municipal court fine cap to $5,000. Does that have any impact on our community at all?
It just allows the city to raise its fines up to that amount, but it doesn't require the city to do that.
Okay, I thought that was the case. And then the governor's budget was actually published today, and his Office of Planning and Budgeting did a presentation on the rather stark realities of the state budget, and that is in the packet I sent you as well. There will be another meeting in December, and I look forward to it.
Thanks, Carol.
Nothing to report this evening?
Okay. Terry, we skipped by you.
No, but I think we ought to thank the community for the Halloween walk. From what I understand, it was a huge success with everything that was going on all the way from Safeway to Gold Hill North, and I know the little guys I talked to had a blast, and they did not want to share their chocolate, and they didn't. So, but
a lot of kids.
In the cultural center, Debbie had the haunted house, and I guess it was a great success. And from what I've heard, there was no damage. My windows didn't get soaked this year, so I was real happy. And from what I understand, and seeing everybody in the community was having a really good time. So
I thank you for bringing that up. I mean, I drove through, and of course it's always just a buzz with activity, and I always kind of forget until I have to drive through there, and I'm like, holy cow, there's a lot of people and a lot of volunteers to make sure that everyone's safe. So
and the weather really turned out great.
Yeah, I hopefully we could order that weather every year.
Yeah.
So I'm sorry I didn't make it to your shop to do whatever to the windows. I was busy this year. Okay. Anything else from council? We do have a report tonight from Aaron.
I do. Thank you, Mayor Pro Tem. I have a brief report, and that is to give the council a preview of the advisement that I will be asking the mayor to make next week, and then any time that council is going to be convening a quasi-judicial hearing. Now that you've got your, electronic devices, which many of you have had prior to this and have received your packet materials through them, but now I think as across the board, council receives their packet materials through the use of the electronic devices. And so you will hear the mayor read into the record next week, and then at any future quasi-judicial hearing, an advisement that will go as follows. Into the record, council members use electronic devices to access the materials relevant to the public hearing before them. Be assured, however, that it is the common practice of the City Council that these devices are not being used for texting, emailing, or other communications during public hearings. So that will be an advisement for, it'll enter the record, it'll alert the audience to the fact that they are not to be sending you texts or emails during your quasi-judicial hearing, because you will not be reviewing those. And then just a reminder to council each time that, you know, the evidence that you need to listen to will be the evidence presented there at the public hearing, and not evidence or statements or concerns or comments that might come to you through constituents or anyone else through your electronic devices. Thank you.
So my father-in-law in Florida can't text me or email me during. He's the one that watches. Okay.
Especially tonight.
Exactly. Okay. No, I didn't. I'm sorry. I know many people watch. Okay, moving on. David.
We have no reports this evening.
Okay. And I don't have any comments on written correspondence, so it is 10 minutes of 10, and we will adjourn the meeting.